Good afternoon and welcome to our second webinar in our healthcare series. Today we're going to be talking about, are your vendors putting you at risk? I'm Carol Amick. I'm the manager of healthcare services at CompliancePoint, where I help healthcare organizations identify, mitigate, and manage privacy and data security risk.
Hi, everyone, and I'm Matt Sulivan. I'm a special counsel in the Washington, D.C. office of Kelley, Drye, and Warren. I work with clients on all types of privacy matters, including HIPAA.
So our objective of today's webinar, we're going to focus a little bit on some key HIPAA concepts. We're going to go into detail on the vendor breach risk. We're going to talk in detail about your covered entity responsibilities in regards to your vendors, and then how you can protect your data.
Well, let me start off by saying thanks to everyone who's joined the webinar. It's great to be part of this presentation with CompliancePoint, and especially having the opportunity to co-present with Carol on this, what really is an important and increasingly important topic. And as you saw from the objectives that Carol just walked through, we're going to cover a fair bit of ground in the next 45 minutes to an hour. In doing so, we thought it would be a good place to start with a brief primer on some of the key HIPAA concepts that really relate to this presentation, with the understanding that many, if not most of you, since you are joining, likely already have some degree of knowledge or experience with HIPAA. But we do want to level set just on these critical concepts. So starting off, why HIPAA? Why do we have HIPAA in the first place? And clearly, the lawmakers, when they originally enacted HIPAA in 1996, were trying to accomplish various things with your healthcare information. It's very much become a law known for privacy, but it did not start off that way. HIPAA includes 5 separate titles, meaning that there are 5 overarching objectives. And that P, as you may be aware, it often gets confused for privacy. The P in HIPAA actually stands for portability, and it really ties back to what was happening at the time back in the 90s, in terms of we had just come out of a recession, and there were a lot of people moving, changing jobs. That portability aspect is that lawmakers wanted to help, ensure that healthcare coverage for workers and their families when they were changing or losing a job. I think we take COBRA for granted today, but having that gap in coverage addressed through things like COBRA, that was really a function of HIPAA. Also providing opportunities to enroll or modify coverage based on life events. So when we go through our open enrollment every year, there's always the caveat that if you get married, if you have a child, that you can make changes to your healthcare plans. And also a core function of HIPAA was prohibiting discrimination in enrollment and premiums charged based on various health factors. Within HIPAA, there was also this administrative simplification provision. And if you think back again, going to the early 90s, and I won't give too much of a history lesson, but these were the days of the early internet. There were national standards in place for electronic healthcare transactions, and the government was really trying to encourage more of these records to move online for the sake of efficiency. And so, of course, if you're going to encourage a shift of data to the online environment, you need to account for how to protect all of that online, that electronic information. And this is where the privacy and data security really has come into play with HIPAA. And when we look at federal privacy legislation, the Federal Trade Commission remains today, they are the main cop on the beat. And they just showed that within the past couple of weeks with the multi-billion-dollar Facebook settlement. But when we talk about enforcement and protection of consumer rights under HIPAA, it's the Department of Health and Human Services, and we'll reference them throughout the presentation. So that is why we have HIPAA now. We'll also want to talk through a couple of key defined terms within HIPAA that are really going to guide the presentation. The first is ePHI, or protected health information. So that is the defined term as far as the data that is covered by HIPAA. And it's a pretty broad definition if you just read that language there on the screen. The first word, any information that can be used to identify a patient. So that's going to include your obvious identifiers like name, address, and email. But it's also going to include, and increasingly so, um, more the types of online persistent identifiers that are linked to each of us when we interact online. So like IP address being a good example. And the list, as the technology continues to evolve, the list of online identifiers that can be considered PHI will also grow. Also within this definition, it's information that relates to the patient's past, present, or future physical or mental or health condition. Relates is a pretty broad term. So for example, if you signed up for a particular health plan and the information that you've provided to do that does not include anything about a specific condition. Nevertheless, that information relates to your present health condition. So that would be viewed as PHI. So again, a broad definition as far as what is within scope of HIPAA as far as the data. What is not in scope is de-identified information. But to be de-identified, it has to meet a pretty rigid de-identification standard under HIPAA. Either an expert has to vouch that that information is de-identified, and the expert would need to rely on statistically valid and accepted approaches, or you have to remove a list of 18 data elements from the data set to, again, to ensure that that information is viewed as de-identified. Okay, so that's our protected health information. Now turning to who HIPAA applies to, or what entities HIPAA applies to. In my practice, often we'll hear from different clients. They'll say, we've got this mobile app. It's collecting health monitor data. It's really more for the sports enthusiast. I think I'm covered under HIPAA. What do I need to do? And the good news in many of those cases is that HIPAA does not apply, because even though the type of data would seem to be viewed as protected health information, it really is critical to look at what entity is accessing, generating, or receiving that type of data. And there's two classifications of entities that are subject to HIPAA. The first is the covered entity. And this would be the more intuitive group as far as what, the groups of companies and organizations that would be subject to HIPAA. It includes your healthcare providers, your hospitals, the pharmacy, the Minute Clinic, health plans, so insurance companies and the company health plans. And then this third category of healthcare clearinghouses. Healthcare clearinghouses can also be considered business associates. It's really an example would be a billing service that processes healthcare data. But those are our covered entities. Those are the organizations, again, that would be receiving PHI directly from their patients or generating PHI in the course of providing services to patients. The next category are the business associates, and that's what really we're going to focus a large portion of the presentation today on. And these are the companies that perform functions on behalf of the covered entity, and they will have access to PHI as a result of providing those services. So, think of your hospital claims processor. They're getting information on the condition of the patient, the treatment that was provided, the associated fees, the patient's information. They're going to be handling a lot of sensitive data that they're receiving from the covered entity, the hospital, in order to perform a service on behalf of the hospital. And there's a whole classification of service providers that may be filling that service provider role. And a key point here is that if there is a relationship between a covered entity and a business associate, where that business associate is accessing or obtaining protected health information, there has to be, that last bullet there, a business associate agreement between the two parties. And it's not just limited to those two parties. So, for example, the business associate may be working with its own service providers who also may be accessing that protected health information. So there needs to be that downstream flow so that you might have a BAA between the covered entity and the business associate, and then separate BAA with that business associate, and then downstream vendors who are also acting as business associates, almost like a sub-processor concept. Now, if done right, the business associate agreement will very closely map to the business associate's obligations under HIPAA. It will address things like indemnification for the covered entity, and really impose all the obligations of the different requirements around privacy and data security on the business associate. And one of the things that came out of some major changes to the HIPAA rule in 2013, that was our omnibus rule that really cleaned up a lot of the elements of HIPAA. And one of the big things that came out of that was that it imposed direct liability on business associates for certain violations of HIPAA. So if the business associate, if they are engaged in an impermissible use or disclosure of PHI, they can be directly on the hook for that misuse. Similarly, failure to notify, if there's a data breach and they fail to notify the covered entity about that breach, then the business associate can be held directly liable. Now, that doesn't mean that the covered entity is not going to have claims filed against it in connection with that violation by the business associate. And that's why you need to have strong indemnification in the business associate agreement. But it does mean that OCR, for example, which is the Office of Civil Rights within the Department of Health and Human Services, that they can investigate and go directly after the business associate. So the chart that you have here on the image on the screen, this is really just to put a kind of a practical illustration of how the relationship works, where we've got the hospital, the covered entity, that is disclosing PHI to these various types of business associates, claims processing, collections, analytics. So as you can imagine, some of that may involve very sensitive protected health information. So we've talked about the data that's within scope, the entities who are subject to HIPAA, and really quickly wanted to just cover some of the key requirements on the privacy and security front. And they fall into two rules, aptly named. The HIPAA, for the HIPAA privacy rule, really what this is that it limits how a patient's data can be used without his or her authorization, and it gives certain rights to the patient. So it dictates the types of disclosures a covered entity, for example, could make. There are permitted disclosures where if you're sharing PHI to provide the service, that is a permitted disclosure. You don't necessarily need the patient's consent for that. An authorized disclosure, which is in the marketing context, if let's say a covered entity has PHI and they want to use that to market to that patient, they would need to obtain an authorization for that. And then required disclosure where there may be some legal obligations where the covered entity would have to actually disclose that PHI. But again, it also provides patients with rights to see their records and seek correction of what potentially may be incorrect information. And in the healthcare space, you can imagine how critical that would be. As a consumer, I think when we go to the doctor's office, we're all familiar with these forms that the doctor gives us when we're signing up that describes what our privacy rights are, and that all ties back to HIPAA. Under the security rule, this was really intended to provide a consistent framework across covered entities and business associates in terms of protecting electronic PHI. And at a very high level, what it requires is a reasonable, that's the standard, administrative, physical, and technical safeguards. And that is, it's a pretty gross oversimplification as far of what HIPAA requires, because HIPAA is fairly prescriptive as to the steps that a company must undertake. So when we're talking about administrative safeguards, that would be a risk analysis, having ePHI policies and procedures in place that are in written form and are maintained and updated, Training of employees would be another requirement under the administrative standards within HIPAA. From a technical standpoint, it's going to be access controls, periodic audits, all of this again documented in writing, and then the physical would be ensuring that your physical plant, your building, has access controls, password protections, and other security measures in place. And I will say HIPAA is having an influence on other privacy laws today. New York, within the past couple of weeks, passed updates to their data breach notification and general business law, where they are requiring companies to have reasonable security measures in place. And really, when I first reviewed the language in that law, it was clear that they took the HIPAA standard and really tried to make that more of a general practice. It's not as prescriptive as HIPAA, but it adopts many of the same concepts. So HIPAA is very influential, not just within the healthcare space, but other aspects of U.S. consumer privacy law. And again, the business associate I mentioned about the liability factor, they are directly liable for failure to follow security rule requirements. So when a covered entity, if you are bringing on a business associate, these security rule obligations are going to be critical to the services that they're providing.
So now that you've all complied with HIPAA, the question is, do we still have breach issues? And of course, we all know we do. This trend kind of shows overall data breaches in the United States. And while in 2018 you see that the data breaches went down in number, you also see that the millions of records reported as breached went up. And we're at a point in the United States where we have 446 million records breached, which means for every one of us, our records are out there about 1.4 times. So most of us have been exposed to a breach at some time or another, either under HIPAA for healthcare or another type of data.
Right, and that's a great point, Carol. That I think it's easy for at this point for us as consumers, for our eyes to glaze over when we hear about these data breaches because they are so common, they're so big. I think to some extent, we're complacent in that we all assume that our data is flowing out there. But again, when we're talking about protected health information, the sensitivity ratchets up, the concern about having that certain information out there ratchets up as well. And when it comes to HIPAA compliance and HIPAA enforcement, it's the data breach that really generates the most publicity, as well as the internal and external scrutiny within an organization. And so some of the kind of the standard functions or aspects of a data breach, when a company thinks that they might have some compromised data, is looking at, do we actually have a breach that's going to be reportable to either consumers or to the Department of Health and Human Services? And so on this slide here, you can see that initial point. Is there a breach? If the breach involves unsecured PHI, and unsecured means that it is unencrypted data. So data that is encrypted to the point that it's unusable, unreadable, undecipherable to an unauthorized person, that is still considered secure data and would not be a breach. So that is one potential way that companies, as they are looking to mitigate their risk under HIPAA, would be to look at different encryption technologies for the data that they're maintaining, so that if it were compromised, then the fraudsters or whoever might be trying to access it would not be able to de-encrypt, and it would also save the company from having some major reporting obligations. But let's say that we do have a breach, then the company has to notify the individual in writing. It has to happen without unreasonable delay or within 60 days at the latest. As far as what the notice would have to say, it's a lot of the information that you would expect to find in a breach notice, not just for healthcare information, but for any type of data breach, financial information, et cetera. A description of the breach, how individuals can protect themselves from harm, where does the investigation stand, and contact information for the company, and in many cases also the regulator. Now, if it's a larger breach, then the entity will have to give notice to the HHS secretary in a timely manner if the breach impacts more than 500 individuals. And also, if it's more than 500 individuals in a particular state, the company will have to notify prominent media outlets in that state to make sure that the word gets out about the breach. So there is, anytime a company in the healthcare space, if you're a covered entity or a business associate, if you suffer a breach, there is going to be a pretty significant reputational impact, notwithstanding the financial impact and other burdens and also the legal risk that comes with it.
And I wanted to pop in real quick and point out that if you live in a state where you've got a breach notification law that's less than 60 days, you also have to do it within the requirements of your state regulation. So if your state says 30 days, you go with the more stringent requirement for reporting the breach to the affected individuals.
Yeah, that's a great point. That's a great point. So some potential silver lining as far as, is a breach always a breach? The answer is no. And again, it goes back to, as I said on the last slide, when you think that you may, if you're a covered entity, for example, you may be subject to a breach, you have to go through the analysis, because there are some exemptions or exclusions from what would be considered a breach. So, for example, unintentional access to protected health information within the organization where there was no malicious intent and no further disclosure. So a file was misplaced, but then it was located. It stayed within the organization. That reasonably would be outside the scope of a breach. If there was inadvertent disclosure of PHI between two companies, both of which are authorized to access PHI, so an example here would be a covered entity accidentally attaches an extra claim file when sending it to an authorized business associate. Again, there's in that scenario, you would expect that there would be a business associate agreement between a covered entity and the business associate. They have a relationship in which they are already exchanging PHI. The risk is going to be very low. And also when there's a good faith belief that the party's not in a position to retain that information. So anytime there's an unauthorized disclosure, it's going to require a very fact-specific analysis to determine whether or not there's a breach. And you really see that in the number 2 here on the chart, which is it can be viewed as outside the scope of a breach under HIPAA if there is a low probability of compromise. And so the elements that will be looked at there is the type of data involved, including the type of identifiers and the likelihood of re-identification. So if you have codes, treatment codes that were kept separate from the actual patients that were associated with those services, if the codes were disclosed, that is PHI, and it relates to an individual. But if there's no other identifiers linking those codes to the actual person, then that might fall within the low probability bucket. Similarly, the unauthorized person who used the PHI or to whom the disclosure was made, you want to look at intent. So if there was a disclosure and it was clearly there was no malicious intent, there was no fraudsters involved from all indications, then that also could fall within low probability. And I'll give you a good example. I had a client where they sent postcards about a dental plan to some of their members, their employees, and they mixed up the name and the address. So I could have received a postcard that had another person at my firm's name on it. Based on that, I could have inferred that they were members of that health plan. But in what this company did, they quickly sent out an email just saying disregard that information. It was sent only within the employee base. There was no confirmation as to whether or not that person whose name was on the postcard was in fact a member of that plan. And they reasonably came out of that thinking that there's a low probability of compromise here. And then the last point, has the risk been mitigated? So again, if there's awareness that there was some type of disclosure, if it was quickly rectified or mitigated, depending on the specific steps that were taken, that also could be low probability. So there's that low probability potential that a breach is not a breach. And that's important to companies because the one thing that you want to steer clear of course, is HIPAA enforcement. And I mentioned at the outset that HIPAA is governed or enforced by the Department of Health and Human Services. It's actually with the Office for Civil Rights within HHS. If you are non-compliant with HIPAA, then the penalties can be stiff. They can exceed $50,000 per violation. HHS has a lot, or OCR has a lot of discretion as to what the actual penalty amount will be. And then state AGs can also bring claims for HIPAA violations on behalf of state residents. So that alone is enough. That is a pretty big stick that OCR has to ensure or enforce HIPAA compliance. Now, where we are today is that HIPAA or HHS has been very aggressive. And you can see there the quote there. This is Roger Severino, who became the OCR director as part of the administration change in the past couple of years. And he came out of the gate saying, look, there's not going to be a slowdown in our enforcement efforts. And I particularly like his quote that they're still looking for big, juicy, egregious cases. And I would say that within the past year, they have gone beyond big, juicy, and egregious cases and are also looking heavily at a whole range of violations. And they've been very, very active, as we'll talk about in the coming slides, as far as enforcing HIPAA violations.
So what is the business associate risk in terms of HIPAA violations? This comes from the HIPAA Journal, and this is their analysis of last year's data breaches by covered entity type. And about 10% of that dark blue, about 10% of the breaches we had last year were related to business associates, about 39 breaches. However, their analysis of the data shows those business associate breaches were 42% of the healthcare data breaches. So obviously, we have some opportunities in healthcare to make sure that our business associates are properly protecting our data. So this is kind of some of the top business associate breaches from 2018. I mean, you can see the large number of individuals impacted, and also a great majority of them were due to hacking IT incidents, which is somewhat different than you might see in a healthcare environment. But this is where we are seeing a lot of trends for last year.
Yeah, and Carol, if I can jump in and make a couple of points on this one. Starting off with the AccuDoc Solutions breach, if you Google that, and I mentioned reputational impacts to covered entities. If you Google that, what's going to come up is it's going to talk about Atrium Health and their patients. So AccuDoc was the business associate, but it was really Atrium Health, I think, who was taking the reputational hit because it was their patients' data. So that really just drives home the point about choosing your partners wisely. And then just another point to make is on the health management concepts breach there. That actually started out as a ransomware attack, and ransomware sounds very James Bond, very high tech, where someone takes hold of your system and locks it up and demands a ransom before they will send you the decryption key to get all of your data back. But the healthcare industry, financial industry, education industries have been hit extremely hard by ransomware attacks over the past couple of years in particular, because that is critical data, and companies are more willing to pay that ransom to get access to their data. And in fact, Health Management Concepts paid that ransom, and in doing so, they inadvertently sent the party that was holding their site hostage, they sent them patient data. So what started out as a ransomware attack, which was already problematic, became much worse as they tried to rectify that information and then inadvertently disclosed patient data. So again, I think there's almost a domino effect here as far as what's happening in the healthcare space today, where There are strict compliance obligations for obvious reasons, but you have parties out there that have malicious intent that are really aggressively going after business associates because they maintain so much data.
And there's the other side of this is, Matt talked about the enforcement, and I went through some of last year's enforcement actions looking for stuff relating to business associates. Filefax was definitely just a business associate. It was impermissible disclosure, but the other three you see on here are actually providers. And all three of these, part of their fine and their enforcement action was due to failure to obtain a business associate agreement with a vendor. The Pasago Springs, for example, if you read it, it appears that perhaps they had an employee who they flipped over to a contractor, didn't take them out of their system as an employee, and then also didn't get a business associate agreement. So anytime you have somebody working in that situation, you just look to make sure you've got them properly classified. The others are just failure to get your BAAs. And when they come in to look, that might not be what got the Office of Civil Rights into your location, but they're going to then look to see if you have good controls around obtaining business associate agreements with your vendors.
Yeah, and that's I think that last point is really important. Cottage Health being a good example where the breach incidents actually were in 2013, 2015, so it was a few years back, and they had some reporting obligations to OCR. And then OCR came in and launched an investigation, and that's when they start peeling back the onion. So they say, oh, well, it looks to us that you did not have sufficient controls in place. You weren't monitoring, you weren't adhering to your security rule obligations. Oh, and then we also noticed that these third-party vendors that were getting access to ePHI, in some cases, you did not have a business associate agreement. So again, it's that domino effect where you can see where once there's some type of trigger that catches OCR's attention, they will come in and as part of their investigation may find a host of other violations.
And we're already seeing activity this year. There's already been several. The Mongo database breach there was 5 million records. Another ransomware, as Matt was talking about earlier, was Doctors Management Service, where there are potentially 200,000 people affected. So this continues. And then there's the big one that I think you've all heard about, the American Medical Collection Agency breach, which affected, at least if you just look at these two headlines, 19 million patients between the two main breaches. And there are actually other organizations involved in this one. So it brings back a point Matt talked about earlier on this. If you look up the breach, a lot of times what you don't see is American Medical Collection Agency. What you see is LabCorp and Quest are the headlines that are going to be on the media, because that's who we recognize as the public, and that's who the media is going to call out when they talk about the breach.
Right, and on that point, yeah, so the headline there, AMCA files for bankruptcy. So they filed for bankruptcy because they lost their 4 largest customers. The companies like Quest and LabCorp are saying, we're not going to work with you any longer. There was the cost of the notice. So AMCA was on the hook for providing notice. But again, that was cold comfort to companies like Quest, like LabCorp, and others that were impacted because their reputation was already dinged at that point. So yes, the BAA has direct obligations, but the damage was done just based on the companies, the covered entities having their names in the headlines. So I think the last couple of slides, if didn't get the point across, just want to reinforce that in the healthcare space today, there's a push and pull. There is a real effort by entities that have malicious intent to compromise protected health information. And then on the other side, you have HHS, which is aggressively enforcing HIPAA. So it really puts the covered entities and all the downstream vendors in a challenging position to comply. And we have some highlights there. These are going back to the start of HIPAA enforcement. These are the latest stats as of a month or so ago. So over 211,000 complaints, over 27,000 cases resolved by changes to privacy practices. Those are big numbers, but again, we're talking over the course of decades. I think what's probably one of the most compelling figures is this third bullet here, 65 cases resulting in $102 million in civil penalties. And those are, decent sized numbers, but if you look at the increase, HIPAA's been around for a while, but if you look at the increase within just the past year, so there's been 10 cases, there were 55 cases a year ago, and $22 million in civil penalties in connection with those 10 enforcement actions over the past 12 months. So that's a clear signal that the fines are getting bigger and OCR is getting more aggressive in enforcing HIPAA. And then the top offenses there, not surprisingly, impermissible PHI use and disclosure. So it's the data breach that is really leading the way. Once a company gives that required notice to OCR that there was a breach, that is usually what serves as the trigger for OCR to go looking at the entity's practices.
So kind of what are the covered entity responsibilities when dealing with their business associates in terms of their breaches and their security? So we're going to kind of go into some detail here. And one of the responsibilities that a covered entity has is to report to the affected individuals within 60 days. And if you look at the timeline on some of these breaches, you'll see that you might not be getting the information from your vendor timely. The AMCA, which was the Quest LabCorp breach, was reported to AMCA by a security firm about March 1st, which means you should have reported it to HHS, your vendor should have by April 30th, and you're started reporting your affected individuals. A Quest was reported on July 1st of this year. As far as I can tell, LabCorp has still not been reported. And probably there's some other vendors the AMCA dealt with that's still not reported. So you have a big gap there. There's another one, ShareCare, which took about 8 months between the time they discovered they had a breach and they reported it to HHS and to the affected individuals. So the media knows there's a breach and you're being contacted by your patients and your families, and you have not reported it because your vendor hasn't done the information within 60 days, is going to affect your reputation in the community. And then there's the question of, is a BAA enough protection? And as we talked about earlier with Quest, particularly, you can see this. They've gotten a class action lawsuit over the exposed patient data. AMCA has declared bankruptcy. The attorneys are not going to be going after AMCA. They're going to be going after Quest and after the other companies that gave data to AMCA. And one of the interesting ones on this one is that Quest actually gave the data to a company called Optum360, who then downsourced the data to AMCA. So your question becomes, if you're Quest, did you really know where your data is? And do you want to be the person having to say, which they say in their press release here, they don't know what individual has been affected and what the impact is. So what do you need to do to kind of get yourself affected if you're a covered entity or if you're a business associate who has other vendors that you're working with? One is to perform an assessment of your current status. The second will be to develop an action plan to address what your issues identify. And the third would be to validate your vendor compliance. And we're going to talk a little bit about what we recommend you do in these areas. The first step is look to see if you have all the required business associate agreements. So who are your business associate agreements? And really the only good way to do this that I know of is to get a hold of your accounts payable activity for the past year, go through it, figure out who's a business associate, and prepare a listing of your business associates. It's a fairly tedious process because you've got to pull out all the employee expense accounts, the doctors, the utility companies, people that obviously aren't business associates, and then you have to look at the rest of your vendors and determine what they're really doing for you and does that make them a business associate. Once you've done that, you kind of have a listing of all of your business vendors, now you've got to get a listing of your business associate agreements. If you have a legal contract system, hopefully that's easy. If you don't, you may be going back to as when I was a privacy officer, the paper files and comparing, making a list of who all I had a business associate agreement. And then the last step is to compare your list of your agreements with your list of your identified vendors, and you've identified who you need a business associate agreement from. And your first action step is to obtain those missing business associate agreements because you're already behind the ball on that one.
Yeah, and a good, just a follow-up point on that. So as I mentioned under the security rule, there's these administrative, technical, and physical steps or procedures that a company has to employ to be compliant with the security rule. And a way to ensure that you are taking your business associate agreement obligations into account is to really make that part of your administrative controls planning, so that it's not just an afterthought or a separate activity, but it is built into your core security rule compliance plan.
So you've got your business associate agreements. I would tell you that you need to check the ones you have to make sure they're current and accurate. The rules and regulations changed with the High-Tech Act. So if your business associate agreement is dated prior to March of 2013, it's probably not got the current legal requirements in it. You probably need to get that one updated. Do you have good contact information? I was a privacy officer for a healthcare provider. I signed BAAs that said if the vendor had a breach, they were to contact me. If they contacted me now, that's not the right person. I'm no longer at a provider organization. So does your vendor know who to contact, or your business associate know who to contact? And have you given them good contact information, and have they given you good contact information? Do you know who to contact there if you have a question about what they're doing in terms of security of your data? And then this last one seems very basic, but we do a lot of audits here at CompliancePoint, and people will hand me a file of business associate agreements, and the front page where you put in the names of the two parties will be blank. And when I flip to the signature page, it's only signed by one or two of the two parties. So you want to be sure that your business associate agreement has been fully executed. That seems basic, but we do see that being dropped a lot. People will sign the first page, the main part of a contract, and maybe not all the addendums. So your second action step is going to be to get updated business associate agreements where you need them.
Right, and just as a general practice, again, having the business associate agreements reviewed, either the templates, the actual content in the agreement, ensuring the proper execution, as Carol mentioned, having that as part of a set schedule, whether it's annual or at least every 2 years, going through that process to make sure that the BAAs remain current and accurate to capture all the HIPAA obligations.
So then the third question is part of validating your vendor compliance. And I know some of you are thinking, why do I need to validate my vendor compliance? I've got an agreement. They say they're going to be compliant. I think we go back to what we just saw with the Quest headlines. It prevents negative publicity. It's going to help prevent costly lawsuit. It's going to protect your brand, which is very important for most of us, and it's going to protect your patients. So I think that's one of the main reasons is kind of that public relations side of why you want to make sure you have vendors who are properly securing your data. So how do you do that? And I'm going to be honest, this is not an easy, quick process of a lot of things. There are a lot of things you should probably look at as you think about validating your vendor compliance. Are your vendors doing a regular security risk assessment? A regular security risk assessment is a requirement of HIPAA. It should be done annually, so they should be doing an annual risk assessment and be able to tell you they've done it, show it to you, and have a remediation plan for identified risks that they found. Do they have good policies and procedures? Do they have policies and procedures that outline compliance with the HIPAA requirements? If you have put anything in your contract specific to your security, have they reflected your requirements in their policy and procedures? Do they have transmission standards? Is the data encrypted during transmission and at rest? How are the encryption keys protected? Have they changed the vendor defaults on their software? Or is that still the encryption key?
Yeah, and as I mentioned on the encryption piece, that whole concept of, is it unsecured or secured data? So if it's encrypted and it's unreadable, undecipherable to someone who might access that information in an unauthorized fashion, then having effective and robust encryption controls could keep that data from outside the scope of what would be considered a reportable breach.
Validate your vendor access procedures. Do they have, is access role-based? Is access monitored to make sure they're identifying security issues? Are they looking for people trying to hack into their system, for example? And then the incident response plan. Do they have an incident response plan that hasn't been tested? Most of us as covered entities have discovered that when we did a walkthrough of our incident response plan, it looked really good on paper, but we needed to do some additional work to make it work in the real world. And so you want to make sure your vendor's done that same thing. Have they tested their incident response plan? Evaluate vendor training. Are their employees trained at least annually on HIPAA? Are there periodic security requirements? Do they do phishing exercises to make sure that there's not the risk of hacking? What are they doing to remind their employees to protect your data? And then, are they evaluating their vendors? So if your vendor has outsourced any work related to your data, does that BAA mirror the terms in your agreement? And did they do a security review? And was it updated annually? This goes back to what we just talked about with Quest, where the data was originally sent to one vendor who sent it on to AMCA. Once the data leaves your control, you want to know where it's going. You want to know where your PHI is going after you send it to your vendor. So you now know what you need to be asking your vendor. How do you really do that? There are a couple of ways you can validate your vendors. You can do it yourself, or you can have someone do it. We do it for some of our clients. We go out and do these things. But these are the methods that we use when we are validating for our clients. The first one is a review of the external audits reviews, such as High Trust, SOC 2. We would encourage you, if you're doing this internally or you're having someone do it, make sure they read the entire report, not just a summary page. There's a lot of good information that you may need and may be relevant to your security buried in the details. The other option, if they don't have an external review, is to send a periodic questionnaire to vendors who don't have a third-party review. You can do this annually. You can do it biannually. You can depend on your risk assessment. They're going to have to be fairly detailed, and you're going to want to review and follow up on your areas of concern. That is an area where a lot of people do find it helpful to have some assistance. And then, of course, you can go out and do audits of your vendor. You can have your IT people do them. You can outsource those audits, but you can go out and actually audit a vendor that you might feel is particularly high risk, maybe has really high risk data for you. For some reason, your IT security is concerned, the reviews, the questionnaires. That's another option you can do. So I think a big thing to know is to have a plan if your vendor has a breach. You need to know who your organization is going to be in charge of the response. You're going to need your own incident response team to evaluate what's going on with that, and you're going to know what's responsible. And then your vendor should have the same kind of plan. What they're going to do, who's going to be responsible for reporting, and their development of a correction action plan. And as the covered entity, you want to validate those corrective actions were implemented. That's really key as part of your due diligence once your vendor tells you they've had a breach.
Yeah, and just one follow-up point on that. So when we talk about a plan, we mean a plan that's in writing, that is accessible. We always tell our clients that if you have a breach, and at that point, once the breach has occurred, you're trying to figure out who you should contact, what next steps you need to do, it's too late. You really need to have a written playbook in place that has all this information captured, that outlines the different scenarios, if there's a breach, and then who you will be contacted, what organizations you're going to be brought in, and really, if it's inside the organization, having designated individuals, named individuals that you will reach out to, who are aware that if there's a breach, they are on point for fulfilling a specific role to help remediate the breach. And again, all that should be captured in writing. Similar to Carol's point on the BAAs about ensuring that the names and the contact information stays up to date. Within the playbook that you're using for breach, that you should take that same approach, where you're doing doing an annual review. And I would say with the breach plan, it really should be an annual review to make sure that all the names, all of the department names, and the contacts remain accurate, so that again, once that breach happens, you can implement the playbook and take first steps on the response as quickly as possible.
So that's kind of the end of our webinar here, but we are going to hang around for a little while and answer questions. And while you're entering the questions in the chat box, I want to take a minute to mention our next webinar is Are You Ready for High Trust? We talked about high trust as one of the ways to mitigate some of the security risk, and we'll be talking about that on September 10th at 2 p.m. So we will now be available to answer questions. So we've gotten some really good questions, and I'm going to try to get through them pretty quickly here. Our first one was from Bridget, and she wanted to know if you have agents answering calls for a customer in another country, do the employees there need to be trained in HIPAA compliance? Matt, what do you think?
I think the answer may be probably. I think it's very likely if we're talking about where we've got an entity who has been tasked by, let's say, a covered entity to act as their call center. So in that scenario, based on our discussion around what is a business associate, if that call center, for example, is going to be receiving protected health information or have access to protected health information as part of providing services to the covered entity, then absolutely they are going to be subject to the HIPAA security rule and and various privacy requirements under the privacy rule as part of being a business associate, regardless of the fact that they are located in a different country. So yes, they're employees. As a matter of course, you would want them to be trained on proper handling of that data, but also under HIPAA, they're going to be obligated to train their employees how to treat that data.
And our second question is, from a HIPAA culpability standpoint, is there a difference if the breach is discovered internally within the company versus externally? I think that my impression is handling it as somebody's dealt with the breach, you're liable regardless of where it's discovered. So, the AMCA breach, for example, was actually discovered externally, but that didn't change the liability of AMCA. Matt, what are your thoughts?
Yeah, I agree. I think as a lawyer, obviously, the first thing I'm going to do is pull up the contract and look at who had custody or control of that data, and then what does the contract, either the master agreement or the business associate agreement, how does it apportion responsibility for that data? And I think that's really going to dictate who is ultimately culpable for the breach.
Justin has asked if there are any data or perspective on benchmarking for liability limits in a BAA. I am not actually aware of any. Matt, do you have any?
Yeah, there's various figures out there. I think as a general matter, you always want the data protection, the privacy, and security terms, particularly when you're dealing with sensitive data, to be subject to a super cap or no cap on liability. And the benchmark that I think I would use right now is going back to that statistic that we showed earlier, that HHS, the Office of Civil Rights, has imposed $20 million in penalties within just the past year, which is a clear escalation in the size and volume of penalties that companies who are non-compliant are facing under HIPAA. So I think if you are in a process of negotiating those types of liability provisions, that is certainly a statistic you can point to try to get the largest cap, or again, no cap at all, on liability with respect to the protected health information.
So we got two more questions. I'm going to kind of merge them together. How often should you perform a security assessment on your vendors, and what do you do if the vendor assessment indicates major issues? Ideally, you'd like to perform that security assessment annually. I realize that might not be possible, especially with a huge volume of vendors. What I would probably do is do a risk assessment of my vendors and try to get through everybody periodically, maybe high risk every year, medium risk every couple of years, that kind of thing, because it is a lot of work to do it. But everybody should have one and then, look at redoing it depending on the risk involved. And then if you have a major issue, I think you've got a couple of options. But now that one of the things this brings up is you really need to address it. It's kind of like the risk assessment in HIPAA. You can't just know the issue and tell the vendor to correct it. You really need to do follow-up and make sure the vendor addressed the issue that you were concerned about.
Yeah, I completely agree. And, I look at this as we're talking about a security assessment, but yeah, the risk analysis and the risk assessment under HIPAA. I look at that as a living, breathing process, not something that you do and then you file away in the cabinet. HHS has put out guidance that is they put it out over a decade ago. It still holds true today that their view the risk analysis process should be ongoing, and while they say it can be done as needed, I think that the target of annual is a good one, or at least netting out which are your high priority or potentially higher risk vendor partners, and maybe doing them annually and others biannually. Really, you want to look at who's getting what access to what data. But the key is that it should be ongoing, and as a result, the teams that are responsible for that should have a calendar that really sets out when they're going to take certain steps with respect to the risk assessment, rather than again doing a risk assessment, putting it away for a year, dusting it off, seeing where they're at. You just want to keep that as part of an ongoing calendar.
So I think that's about all that we have time for now. If you want to send us any other questions, it's connect@compliancepoint.com, or our email addresses are up there. I'm sure Matt and I will be glad to respond to anything personally. Our next webinar in our healthcare series is Are You Ready for High Trust on September 10th at 2 p.m. Eastern, and we look forward to talking with you.